Sprinting to the future of law. Heaven, help us. Global connectivity through space internet. Part 4. Legal and regulatory issues. In the previous part of this issue, we reviewed several applications of space internet that are not easily viable with terrestrial wired and wireless internet services. Now let's look at various legal and regulatory considerations involved in space internet. First is licenses and authorizations. Every space internet system provides internet coverage that spans across many nations. A huge challenge is the varying regulatory approaches of nations in dealing with internet access for their citizens. There is a need for international coordination to avoid conflicts among the differing regulations. In India, some of the regulatory requirements include obtaining authorization to own and operate an Indian registered satellite system, including for the Spacecraft Control Center, authorization to operate a ground station in accordance with the radio regulations published by the International Telecommunications Union or ITU, and a license to provide services from satellite systems. Spectrum allocation. Space internet operates on a limited radio frequency spectrum that is suitable for space-to-ground communication. Allocating and managing the radio frequency spectrum for satellite communication is critical as the demand is increasing rapidly. Space internet providers have to seek and obtain necessary licenses and authorization from the relevant regulatory bodies in every nation in which they want to provide services. Coordinating and allocating these frequencies fairly and efficiently among multiple providers while also considering terrestrial users require a robust regulatory framework. The International Telecommunications Union (ITU) plays a crucial role in this process, especially coordinating the use of frequency bands across nations to prevent interference among satellite systems and ensure efficient spectrum utilization. Data protection. Space internet providers would need to ensure compliance with the applicable data protection laws, especially about the collection, storage, processing, and transfer of user data. While operating in multi-jurisdiction and legal systems, managing data sovereignty issues is critical for the providers. For India, if a provider processes personal data of a user, it would have to mandatorily seek the consent of the user, disclose the purpose behind data collection and processing, and set up procedures to seek grievance redressal for the user. Liability and insurance. Determining liability in the event of satellite collisions, service interruptions, or other incidents is a complex legal issue. International treaties are needed for liability standards. Space internet providers and satellite operators may also need to secure insurance coverage. Intellectual property rights. Space internet systems and satellite technology in general involve significant level of intellectual property or IP. IP rights protections are typically provided within a specific jurisdiction with some reciprocity to other jurisdictions. However, due to the extraterritorial nature of these technologies, space internet companies may face legal challenges related to patents, trade secrets, and other intellectual property rights. The Outer Space Treaty of 1967 establishes broad principles for space activities by nations, but specific regulations for space internet are lacking. Which national laws will apply to satellites and their operations, and how to handle issues like data privacy and cybersecurity across sovereign boundaries remain unresolved. This is further complicated by the increasing involvement of private companies. In the next part, we will go deeper and discuss even more complex national security and environmental concerns with space internet.